Good morning, or afternoon, or evening, whenever you're watching. I'm your anonymous attorney, here to tackle legal questions swirling around the YouTube sphere. Today, we're stepping into Girl World to unravel a legal drama involving Foodie Beauty, aka Chantal Marie, and a whirlwind of international law. Here's the lowdown. Our Canadian YouTube sensation, or Kuwaiti YouTube sensation, Chantal, got mixed up with a shady character who's now facing criminal charges in Canada. This unsavory character mentioned that Chantal might be called as a witness in the trial, which sparked quite a bit of discussion in the comments by Chantal and all of the reaction channels. But Chantal claims she can't be called to testify since, she's living in Kuwait, and later on tried to say that the longer she's in Kuwait, she is severing ties with Canada.
Listen, I wanted to address, I see look, if it's just haters saying, oh, you're going to be going and defending Natter and blah, blah, blah. I don't care about these people, but when I have legit comments and questions from supporters who think that, there's a lot of misconception going around, okay? And a lot of dumb rumors. No, I'm not testifying for anybody. I have not even been contacted. Look, I'm in another country. I'm a resident of another country. Nobody can touch me, okay? I have not been subpoenaed.
As you heard, she hasn't received a subpoena yet. But can she actually be summoned? Contrary to Chantal's beliefs, she can actually be summoned as a witness, even from Kuwait. Although no specific agreement exists between Canada and Kuwait for cooperation in criminal matters, like an international treaty, that doesn't mean Chantal's off the hook. In fact, if the Crown or the defendant's team want Chantal's testimony, they will make a formal request to the Kuwaiti government, which might not be good if Chantal's status in Kuwait isn't as clear as she makes it seem. This will involve drafting something called a letter of request, which is a document detailing the case, the witness's identity and location, the testimony's purpose, and the subpoena's delivery method. Once the Kuwaiti authorities respond, the Canadian court will be notified if the subpoena has been served. If the subpoena has been served, then it will be up to Chantal to arrange her testimony, either in person or via video conference, which is all subject to the Canadian court's approval. But a question remains. What if Chantal snubs the subpoena? Then what?
I don't want to talk about it. I don't even want to be involved in any way.
In a Canadian criminal trial, witnesses who fail to show up without a valid reason to court under a subpoena can face legal consequences, like being held in contempt of court or face other monetary penalties. Witnesses like Chantal need to grasp their role in the legal process and the potential repercussions of skipping out in court. If they have a legitimate reason for not attending, that should be communicated with the subpoena issuing party, or they need to seek legal advice to explore their options. As you can see, Chantal can be subpoenaed even if she's not in Canada, and the consequences of ignoring a testimony request can be severe. Keep in mind, though, that my information is based solely on what Chantal has shared publicly, and I don't have a full picture of the entire situation. But as an international law enthusiast, I just couldn't resist dissecting this today with you. Got a question about what we just discussed today? Drop it down below as well, and I'll do my best to answer. As a reminder, while I am an attorney, I'm not your attorney, nor Chantal's, so this is not legal advice. Thanks for watching, and I hope to see you in the next video. Bye!